This changes everything. The Supreme Court has just delivered a 9-0 unanimous decision that no one expected, a ruling that's shaking America to its core and rewriting how the nation understands both the Second Amendment and the Fourth Amendment. When was the last time all 9 justices agreed on something this controversial? Almost never. And that's what makes this moment so powerful and so unsettling. This decision doesn't just affect the courtroom, it reaches into your home, your privacy, and even your right to defend yourself. It challenges decades of interpretation, setting a precedent that could redefine the balance between freedom and control, security and surveillance. Some are calling it a victory for liberty, while others are warning it opens the door to a darker era of government power. But what exactly did the court decide? Why are both gun rights advocates and privacy activists reacting so intensely? And how could this ruling quietly reshape the daily lives of millions of Americans without them even realizing it? We're going to break all of that down in this video, step by step, and trust me, by the end, you'll understand why this is being described as one of the most important Supreme Court decisions in decades. But before we dive deep, smash that like button and subscribe to the channel. It's not just for numbers when you interact. YouTube shows this video to more people who deserve to know what's really happening. Your support helps spread truth and keeps independent voices alive in a time when censorship and bias are everywhere. So hit like, subscribe, and turn on notifications. And after you've done that, tell me in the comments what shocked you the most. Your opinion matters here. Now get ready, because the final revelation in this story will absolutely leave you speechless. Don't miss a second. What's coming next will change the way you see the Supreme Court forever. Attention, everyone. The Supreme Court just dropped a bomb, a 9-0 unanimous decision that is already reverberating through America's legal foundations and rewriting how we understand two of the most sacred protections in the Constitution, the Second Amendment and the Fourth Amendment. What you're about to hear may shake your assumptions about self-defense, police power, privacy, and the limits of government. Is this the dawn of a new era or a trap disguised as progress? Before we plunge in, don't forget, smash that like button, subscribe, and ring the notification bell, because your engagement literally helps this video reach other people who must see this. Your click matters. And afterward, drop in the comments what surprised you most. Your voice is part of this fight. Now buckle in. 1. The unanimous ruling. A rare moment of consensus with explosive implications. It's almost unheard of for the Supreme Court to rule unanimously on a hot-button constitutional issue, and yet here we are. In the case Barnes versus Felix, the court addressed the question whether courts should apply the moment of threat doctrine in excessive force claims under the Fourth Amendment. Lower courts had split over whether liability should be judged only at the instant danger presented itself, or whether courts could consider the full context, the lead-up, warnings, officer perceptions, posture changes, escalation. The court, in a unanimous opinion by Justice Elena Kagan, rejected the restrictive moment of threat approach and held that courts must consider the totality of the circumstances, including events before and during the encounter. The decision explicitly warns against putting on chronological blinders that exclude prior facts from review. This uniform agreement amplifies the ruling's weight. It is not easily dismissed as ideological or fractured. It is doctrine, for now, firmly set. 2. Fourth Amendment overhaul. From micro snapshots to full narrative review. The heart of the ruling is a transformation in how courts evaluate claims of unreasonable force. Under previous doctrine, many courts adopted a blinkered approach, focusing only on the precise moment an officer believed force necessary. But the Supreme Court now holds that such snapshot reasoning is too narrow. Instead, courts must look backward and forward. How did events evolve? Were there warnings? Did the suspect get progressively aggressive? Did communication or de-escalation efforts exist? The court insists that the reasonableness inquiry be holistic. This change means that many lower court dismissals, often on summary judgment, may no longer be available. More cases will survive early dismissal and reach juries. Departments will face scrutiny not just for the trigger pull, but for all the seconds that led there. Some law enforcement advocates warn this opens the door to hindsight bias and micromanagement of police decisions. Critics argue it invites judicial second-guessing. But supporters say this is precisely the accountability we needed, that constitutional rights deserve context, not compartmentalization. 3. Where does the Second Amendment fit in? A subtle but critical connection. The ruling is ostensibly about the Fourth Amendment, so why is this making waves in Second Amendment circles? Because the logic of rejecting rigid, mechanical doctrine in favor of contextual, flexible analysis may bleed into how courts treat firearm regulation. The court's message is clear. You can't freeze constitutional questions into a single moment and ignore what led up to them. That same insistence may challenge overbroad, rigid laws targeting guns. In Second Amendment jurisprudence, courts wrestle with how to interpret restrictions based on history and tradition, as reaffirmed in Bruin. If this new ruling signals judicial hostility toward bright-line rules divorced from context, future challenges to carry restrictions, magazine bans, or categorical prohibitions may find fresh footing. Observers are already speculating that the unified voice on police power could fortify arguments that gun regulation must be evaluated with nuance, not blunt categorical reasoning. 4. Reactions, critiques, and the battle lines being drawn. The unanimity lends legitimacy, but it doesn't erase conflict. Civil rights groups praise the decision as a guardrail against arbitrary power. Police organizations and defending attorneys worry about chilling effects, hesitation in crisis moments, and endless litigation. Among the critiques, will courts now require experts to parse every pre-conflict detail? Will officers be punished for split-second judgments made under stress? On the Second Amendment side, gun regulators may worry that this ruling is a Trojan horse of precedent to chip away at regulatory authority under the banner of contextual review. Some scholars warn of doctrinal instability. If every case must be evaluated contextually, predictability suffers and rules lose clarity. Yet, paradoxically, the fact that all 9 justices endorse this approach gives opponents less room to accuse it of being partisan. The ruling isn't a compromise, it is a statement. 5. Impact on policing, liability, and internal policy. The real-world consequences are massive. Police departments nationwide will have to reassess use of force training, incident reporting, escalation protocols, decision documentation, de-escalation procedures, and risk assessment. Legal teams and insurers must recalibrate exposure. Many claims once dismissed may survive motion practice. Internal reviews will need to scrutinize warning chains, communications, timing, posture changes, escalation paths. All the moments before will matter. Some departments may respond with greater caution in active confrontations, fearing that officers will be overexposed to litigation. On the other hand, the ruling could encourage more transparent, defensible decision-making, clearer policy design, and stronger documentation. The liability landscape shifts. You no longer defend only the moment of contact, you must defend the narrative that preceded it. 6. Future constitutional fronts where this decision will echo. This ruling opens the door to a cascade of challenges. On the Fourth Amendment front, expect renewed battles over search warrants, no-knock entries, surveillance, qualified immunity, digital searches, body cam footage, and data intrusions. With the court emphasizing full context, arguments about warrantless search exceptions may intensify. On the Second Amendment front, watchers anticipate challenges to assault weapon bans, magazine limits, registry rules, restrictions on carry, restrictions on citizens under civil orders, and more. Already, in United States versus Rahimi, the court upheld a law disarming individuals under domestic violence restraining orders in an 8-1 decision, but that decision could be re-examined in light of evolving doctrine. States that have laws built on rigid thresholds may find themselves vulnerable to constitutional challenge. The Barnes decision may be cited in future petitions for certiorari, potentially reshaping how gun cases are litigated. 7. What this means for you, why every citizen, gun owner, and privacy defender should care. At its core, this is not just a decision for courts, it's a decision about your encounter with power your rights under stress, and the treatment of constitutional protections as living, contextual guarantees instead of rigid formulas. If courts demand that every narrative, every warning, posture, communication, escalation be part of the calculus, then no encounter is trivial. Your gun rights may find more leverage in demanding judicial consideration of context. Your privacy arguments may find reinforcement in resisting bright-line rules. And all of us who believe in constraint on state power should heed the message. Constitutional analysis must embrace nuance, not paralysis. Because of the unanimity, this ruling will carry enhanced legitimacy and may influence many less visible cases behind the scenes. The ground under our legal structure has shifted. This 9-0 ruling is a signal flare as much as a checkmark in the record books. It proclaims, doctrine cannot be mechanical. Rights cannot be abstracted from reality. Courts must see the whole story. It doesn't give all the answers, but it changes the game. The stakes are higher than courtroom debate. This is about how power is perceived, how citizens are protected, how the law is lived. If any part of this unsettled you, tell me in the comments what hit you hardest. And again, subscribe, and share. Your engagement pushes this vital conversation into more eyes and ears.